Okay, good morning, everybody. Matt Braden here from the GPAR team. Welcome to this morning's workshop. Hope everybody had a great week as we get ready for the weekend. Before we get started with Trent's presentation, just a couple of housekeeping things. Code of ethics. This is a reporting year. Hopefully you guys have taken care of that code of ethics requirement. The deadline for that is at the end of the year, but we're really trying to work with our members to get things squared away. Usually we have this crazy rush at the really roughest time of the year to go ahead and take care of that requirement. So we're trying to do it now when it's nice, hot, humid, and the summertime, as opposed to waiting until we're in cold weather in December. So if you receive messaging from us about code of ethics, please get it squared away. We're doing a workshop next week. Register for that workshop. It's going to be hosted by us and Heather Patron-Shook, a great presenter. It's a great way to go ahead and do it. If that doesn't work for you, please use the option on NAR's website. You can do that at your leisure. You start the workshop there, and then you have 30 days from the day you started to complete it. So you can do it in bite-sized nuggets over the course of a month and get that squared away. So there are two ways. And then always, if you go ahead and you do continuing education, that's another way. If you have done continuing education and it's an ethics course, get that certificate of completion into Donna LaPera from our team. Why waste any more time? You already have it done. Get that in, and then we can get you off of the list, and then you're good to rock and roll. So again, code of ethics. If you've have it taken care of, wonderful. If not, let's take care of business now. Talking about business and finances, if you will, GPAR is about to announce the opening for enrollment in our Easy Pay plan. That's an option in which you're able to spread out dues payments for next year on the second half of this year. Sometimes that's really good for people in terms of budgeting and just paying it out over increments as opposed to one big bill at the start of 2022. Keep an eye on your inbox for messaging about that, about how you can enroll. Gina Rowley from our team handles all of that. So the more people we get enrolled in that, the better. It makes things easier for folks. And then once they submit their enrollment form, they don't really need to worry about it much. So just keep an eye on messaging from us about the Easy Pay plan for 2022. So with that, we're going to now get into our presentation today, and our presenter, Trent Pettus. Good morning, Trent, from sunny Florida.
Yeah, good morning, Matt. Good morning, everyone. Yeah, sunny Florida. I should be back in Philadelphia, but I'm loving it so much. I've been here for 3.5 weeks. But I will be back in a couple of days.
So Trent, what I'm going to do for you is and all of our attendees here is I'm going to be dropping in. I just put the link into the chat. It gives you access to the various forms that link is going to be referencing today. And then I will also drop in the files of that as well, which will be a PDF. So you can, whichever works best for you, you can use the clickable link or the forms. Just give me a moment. It'll take a little while for those forms to drop into the chat. And the floor is yours, Trent. Go ahead.
Oh, no, I'm sorry. What did you say, Matt?
The floor is yours, Trent. Go ahead.
Oh, thank you. Good morning, everyone. How's everyone?
Good.
Good. Thank you, Cheryl. You all don't, and
Outstanding.
When I do these presentations, I like you all to participate. I want you to be an active participant. If you want to interject, feel free. If you have questions, ask them, interrupt me. You don't have to wait. We're not going to wait till the end of this presentation to take questions. Let's talk. The nice thing about these, oftentimes we have experienced agents, seasoned agents on who can also offer up some advice. I never claim to know everything. And there are always different ways of looking at things and doing things. So I always welcome the comments from seasoned agents, new agents. And so we like to make this just a fun experience. So having said that, let's just get started. Also, if you can put your videos up, I always like to see people because I'm looking at you all on my big screen TV and I see all this black. I would love to see videos, but for some, if you can't, I understand. But if you can, it makes it a little easier for me to do presentations when I can see people other than Cheryl. Thank you, Cheryl. and Donna's dog. All right, let's talk about the buyer agency contract. Let me ask first, how many of you are new agents? So do we have any like brand new agents who've not done any transactions yet, never written up any buyer agency forms or agreements of sale or listing contract? Anybody who's brand new?
I haven't.
All right, Gabriella, what is it? All right, anyone else? Anyone who's relatively new, maybe been in a business, less than 6 months, 8 months, 10 months. Most of you, could somebody just say something to me. How long have most of you been around? Can just give me an idea.
8 years.
8 years.
Too long.
25.
All right. 5 years to 8 years. Okay, let's go.
25.
Did somebody say 20? Oh, Lisa, 25.
Yeah.
25 is a long time. I'm only 26, so yeah, it's a long
Brent,
time.
I heard it too long. So I think that's a very official chronological number. Too long.
All right, let's get started. Let's talk about the buyer agency contract. First of all, I always like to start. What is the first form when you meet someone, what is the document that you ought to give that customer who at that point is probably not a client, but is a customer? What's the first form you give to someone when you have what we call a substantive conversation about real estate?
Am I right?
Yep.
Consumer notice.
A consumer notice. A consumer notice. And I'd like to let's talk a minute about the consumer notice. The consumer notice, let me just read from it. Is up here. The consumer notice is not a contract. For newer agents, sometimes every now and then you'll find some clients or customers or consumers don't want to sign a consumer notice. Just remind them, it says on the top that it's not a contract. Just remind them that this is something that the law requires me as a licensee or as a salesperson to give to you to inform you of all the different business relationship choices you may have with me. That's why in the consumer notice, it tells you, these are the different, it says the licensee or the salespeople or associate brokers may enter into the following agency relationship with the consumer. You could be a seller's agent. Obviously, if you're a seller's agent, you represent the seller exclusively. You could be the buyer's agent. Obviously, you would represent the buyer exclusively. You could be a dual agent, which means you could represent both the buyer and the seller in the same transaction. Sometimes agents, see someone, when I also teach at Temple, and sometimes my students think, when I say dual agent, they think that you have to represent both the buyer and the seller, the same salesperson. But keep in mind that even if you are in an office, let's say you're Keller Williams Philly. Keller Williams Philly is the broker. All contracts are between the broker, the company, the brokerage, and the buyer, and the seller. So if you are Keller Williams Philly and you represent the buyer and the seller, then even though they're two separate salespeople representing the interests of the buyer and the seller, Keller Williams is a broker in each one of those contracts. So Keller Williams would still would be a dual agent, even though you represent the buyer, someone else in your office represents the seller, but it's the same company. Therefore, the company, because Keller Williams Philly would be the contract in this example would be between Keller Williams Philly and the buyer, and Keller Williams Philly and the seller. So Keller Williams Philly is the broker representing both parties. Therefore, it is still a dual agency. And when you have dual agency, you must get written consent from both the buyer and the seller. Otherwise, you cannot represent both the buyer and the seller unless they consent in writing. You can't get oral consent. Remember, you must always get written consent in order to be a dual agent. Designated agency, your office, you will know whether or not your office practices designated agency or not. That's something you need to talk to your broker about. If you don't, and designated agent, well, I don't need to talk about it, but you will know, and we'll talk about it in a minute when we get to the buyer agency form. transaction licensee. If you're a transaction licensee on the consumer notice, it just basically, you're just doing paperwork. You're not representing either party. You're in a non-agency capacity. The only thing you do is help a buyer or seller complete paperwork. You're not giving them any advice. You're not giving them any consent. Only thing you're doing is doing the paperwork. They come to you and say, hey, my cousin wants to buy my house for $50,000. He wants to put down $20,000 and close into the month. All you're doing is filling in the paperwork. You're not saying, how much are you selling that house for? $50,000? That seems awfully low. No, the only thing you're doing is you're not representing either party. You're simply doing paperwork. You're just making sure the consumer notice is there. That seller gives us, seller's disclosure, that lead-based paint. You're making sure all the documents and mandated disclosures are there. But you're not there to give them any advice. You're not saying, you know what, I think you should get a home inspection, or I think you should probably not pay cash. I think you're just simply doing paperwork. All right. But so keep in mind a consumer notice. If this person does not become a client, you, the agent, many agents don't seem not to know this, even brokers, I think, forget this. You have to keep this form for 6 months. You have to keep the consumer notice for 6 months. If they become a client, there's a file in your office. Your broker then has to keep it for at least 3 years. But you, the agent, should keep a file of consumer notices. Now, if you email them properties, obviously they have to click that they received the consumer notice, and you can have proof there. But if you met somebody who came into the office, or you met them at some location, first thing you need to give them is a consumer notice if you're having a substantive conversation about real estate. And when we say substantive conversation about real estate, we're not talking about someone asking you the price of a house. Anything that's public information is not substantive. If I can go online and see this has 3 bedrooms, 2 baths, and it's 1,400 square feet, that is not substantive. But when I call you and say, hey, I want to buy a house and I have a pre-approval from the police and fire credit for $300,000, I have $50,000 saved, and I want to be in a house by the end of September, you need to stop that buyer, that client, that consumer, and then say, let me get you the consumer notice, because they need to know that any information they give you at that time is not confidential, and that information could be used against them. Because, for instance, let's say you represent the seller. They call, they see your property listed in Roxborough, and they call and they ask some questions. They talking to you and they say, listen, I love this block. I've always wanted to live there, and I'm willing to pay full price. And you're the listing agent. You don't give them consumer notice. They're giving you information that is, I would argue, is confidential. Well, then let's say they now go to another real estate brokerage. You get a contract from this company, and you're like, wait, I remember that buyer. That's the buyer who called me and said how much they love this property and they've always wanted to live on this block. And it's listed at $400,000, but they offered $350,000. I'm like, So I say to my seller, well, you know what? This person called me. They tell me how much they love it. $350,000 we would take. The seller said, I'll take it. But why don't we counter at $400,000, since I know that this person will pay that? Well, because that consumer gave you information that, they were not they were not clients, they were just a consumer, because consumers, when they talk to you, that what they're saying to you is not confidential. Once they sign that buyer agency contract with you, everything you say is now what they tell you is confidential. I then, as a seller, use that information against you, because you simply called me on the phone, gave me some information, and we're not in any kind of agency relationship. So you, as the consumer, could be hurt if you disclose information that you don't want disclosed. Therefore, as an agent, you must let them know that the information you're giving me, and there's an oral disclosure thing is there. If you're on the telephone, you can't get them the disclosure. There's an oral disclosure that must be read verbatim. If they're gonna give you substantive information, they start talking about their motivations, their needs, you need to then stop them and say, I have to read an oral disclosure notice to you. And that way, now they're told that information, let's just read it. It says, and you have to read it verbatim. It says, the real estate law requires that I provide you with a written consumer notice that describes the various business relationship choices that you may have with the real estate licensee, like myself. Since we are discussing real estate without you having the benefit of the consumer notice, I have the duty to advise you that any information you give me at this time is not considered to be confidential. And any information you give me will not be considered confidential unless and until you and I enter into a business relationship. In other words, a contract. At our first meeting, I will provide you with a written consumer notice, which explains those business relationships and my corresponding duties to you. Once you give that consumer notice and they continue to give you confidential information, then that information may be used against them because now they know, well, wait a minute, you're representing the seller, right? Yes, I'm the seller's agent. I'm not your agent. So keep that in mind. But if I enter into a contract with you, then I'll become a dual agent and I owe you confidentiality also. Any questions, comments?
So Trent, do you think, going back to transaction licensee, do you think the future of the industry is going to go towards more of transaction licensee, so all this fiduciary responsibility is alleviated? Because I've been hearing stuff that, some people are considering that as far as a trend for the future. Well, what are your thoughts on that?
In Florida, you know what, that's almost like the way it is here in Florida. I have a broker's license here. I'm beginning to do business here. Most people in Florida don't represent buyers. They don't sign buyer agency contracts. They don't represent buyers at all. It's rare, I'm told, for you to enter into a contract with a buyer. You have a non-representation agreement with a lot of buyers, which of course I'm still kind of having to get used to. So yeah, I could see that happen, and absolutely that could. I definitely see it happening here. I got to get used to the way they do things here, but yeah, I could see that happening. I hope.
Right. It's funny you say that because I'm here in Florida too, and I'm getting my broker's license here in Florida as well. And that's exactly where I got it from, where they're doing it here in Florida.
Yep. Well, that's exactly what they do it in Florida. Absolutely. And it could be a trend. I kind of hope not. All right, let's go. Any other questions, comments? All right, let's go to the buyer agency contract. We're going to talk about the buyer agency contract that we're looking at today is the exclusive buyer agency contract. And you can use this if you represent a tenant. That's why it's a buyer, tenant agency contract. But we only going to deal with it if you represent the buyer. I actually think they should call this an exclusive buyer agency contract because that's what it is. This is an exclusive buyer agency contract and not a non-exclusive. If you wanted a non-exclusive agency contract, there is a form, it's actually called an NBA form, and it's called the non-exclusive buyer agency. An exclusive buyer agency contract means that when that buyer comes to you, and if this contract goes until the end of September, no matter who finds that buyer a property, that brokerage earns the commission. So if the buyer finds a property, him or herself, if the buyer, if another office finds a property for that buyer, it does not matter. Not an exclusive buyer agency contract, which obviously I think is the best one to have. I don't use any other ones. A lot of brokers probably don't, but this means that you have earned your commission regardless of who finds that buyer contract. And if you go down to paragraph 2C, because an exclusive agency contract must state that the buyer, what I just said. Take a look at paragraph 2C. It says the balance of the broker's fee is earned if the buyer enters into an agreement of sale during the term of this contract, whether brought about by the broker, one of the broker's licensees, or by any person, including the buyer. That's the language that has to be in a buyer agency contract. This is a language that makes it an exclusive buyer agency contract. And so make sure buyers understand if they find it themselves, if they're one of their coworkers say, hey, I have a house I want to sell you. It does not matter. If they buy a property during the term of this contract, you have earned the commission. All right. Let's take a look at, and also what's another key point? I would say and I bet you some seasoned agency would tell you they do not even have buyers sign buyer agency contracts. I could be guilty of that sometimes until they find a property, because if they want to go somewhere else, I'm really okay with it. If you don't want to work with me, I'm fine. But just keep in mind, you don't have to. Now, let me say this: you should have a buyer agency contract signed. Let me be clear. You should have a buyer agency contract signed when you meet a buyer. But you don't have to have one But in order to earn a commission, to earn a fee, you must have a buyer agency contract. You cannot earn a fee. The Real Estate License and Registration Act says that you can provide services to a buyer without a buyer agency contract, but it also says that you're not entitled to collect a fee without a buyer agency contract. Remember, the contract this is an employment contract. The buyer has hired you to help him or her find a property. If you don't have an employment contract with the broker, then you're not entitled to a commission. You're simply a volunteer. So just keep in mind, I believe is as good practice to have one signed. And here's one thing that I do. If I had a buyer who says, you know what, I don't want to sign a long-term contract, or then you simply say, let's make it a 1 week contract. Let's make it for 1 day. I have signed buyer agency contracts for people who didn't want to sign a contract for one house. They want to see one house. I say, okay, if you buy this house, then I've earned a commission. But if you go buy any other house, I don't. So this is how you can get a buyer to sign a buyer agency contract if they don't want to sign a contract. Say, okay, I'm going to take you out on Saturday. All right, we'll have a contract that's only good for Saturday at midnight. At midnight on Sunday, at 11:59 it ends on Saturday night. At midnight, well, it ends at midnight. All right, so do that. Tell a buyer and say, hey, if you don't want a 3-month, a 4-month, or 1 year, whatever it is, let's just do a short term. Most buyers will feel comfortable with that, and they will go with that. Do I have anybody who would agree with that who's been in business for a while?
Yes, Trent, I absolutely agree with that. I only work by referral, which is why I'm here today, because I need to educate the new people, my new partners, on having this and utilizing this in order to justify being procuring cause should any conflict arise. But I have found it helpful in the past that clients are receptive to signing for 1 day. I would do it for 1 tour. If I'm taking you out on a tour on Saturday and we're seeing 6 houses, that's inclusive of this contract. It's the tour that I'm taking you for. It's 24 hours or 1 tour. And so I find no resistance with that. So I absolutely agree with you.
All right, thank you. And I would agree that if you have a problem, if you're a younger agent or newer agent and you get some resistance from that buyer, just say, we'll just make it for 1 tour, as Lisa says, 1 day, 2 days, whatever. And most of them will be comfortable with that and they'll sign it. All right, so let's look at the buyer agency contract. Again, this is an exclusive buyer agency contract.
Hey, Trent, can I jump in for a moment?
Yes, sir.
Got a question in the chat, and I just want to make sure that you may have answered this, but I want to make sure we get it answered. With dual agency, where both agents are with the same broker, buyer, and seller, are both to consent in writing?
Yes, they should have, both of them have to agree, because anytime there's dual agency, both the seller and the buyer must give written consent in writing. What I would do in my office, I have a form that I use that I require the buyer and the seller to sign, saying, hey, this agent, this office is, will represent both you and the seller. And we just want to make sure that you are okay with it. You are giving us your consent. Every now and then, I've been in this business a long time. I think maybe 2 times in my career, I've had buyers and or sellers say, I would rather you not be a dual agent. Most people won't have a problem with it, but every now and then you're going to find someone who says, no, I'd rather you not represent the buyer if you represented me, the seller. So that's why you need written consent. That way you never have a problem. Make sure you get written consent. Get written consent. Even if you had to write up something yourself, just write up something, do an addendum saying the buyer and the seller agreed to dual agency and have them both sign. I always like to protect myself. I just always cover your bases. All right. Go back to the buyer agency contract. The name of the company, obviously under the broker or the company, you write the full company's name, the license number, you should have that. You know the address and the main phone number. The licensee, that would be your information. If there's more than one licensee or salesperson, you should put their information there also. Sometimes there are 2 agents or co-listing agent. Put the name, put the name of the co-listing agent and all their telephone number, license number, put all the information there too, because they also represent this buyer. All right. Buyers, make sure under buyer, you list all the buyers, because you don't have you want to make sure all the buyers are listed to make sure that each one is fully bound to this contract. So don't leave any buyers out. If you're working, but if 2 buyers are going to be on the contract, make sure both buyers sign this contract. If there's 3 buyers are going to be on the contract and make on the agreement sale that they eventually enter into, make sure all buyers' names are listed. You can put the buyer's mailing address, phone number, and all that. You should have this, because if you ever need, your office will probably want that. Your office administrator, your broker, you don't know if you ever have to contact these buyers again. So I would fill that information out. Now, one of the things that sometimes buyers don't seem to know, this next sentence says, a buyer understands that this buyer agency contract is between the broker and the buyer. In other words, to the buyer, this contract is between my company and you. I just happen to be a representative of the company. If I quit and I go from Compass to Berkshire, I can't take this contract with me. This contract does not belong to me. This contract belongs to the broker. So they explain to buyers that this kind of, I don't know if you have to go into detail about it, but sometimes they think if you move, they can automatically move with you. But that's not the case unless you get the broker to give permission that you can take this contract with them. Does a buyer have a buyer agency contract with another broker? This is one that if they say yes to you, that should raise a red flag, and it should get you to asking questions, because if the answer is yes, then you need to ask, well, why? Because now, if they already, take a look at, let me show you, go down to, for a minute, to look at paragraph 1B. We'll get to it in a minute, but it says, that second sentence says, buyer will not enter into a buyer agency contract with another broker / licensee that begins before the ending date of this contract. So a buyer should not be enter into another contract before this contract ends. So if that buyer says, I have entered into another contract with another brokerage, you need to ask why. I remember once asking, and they said, yes, I have a contract. And I said, well, what, why? Or when does it end? And they said, it ends today. It ends at midnight. So I want you to start representing me. I want you to sell my property. Represent me as of tomorrow. So that makes sense, because they can sign a contract that begins after the end date of this contract, but they should not. They could enter into another buyer agency contract. They shouldn't. But one thing that can happen, if they enter into 2, they may be responsible for 2 commissions. Because if a buyer has 2 buyer agency contracts, the contract says that whoever, no matter who finds them that property, they owe a commission to that company. Well, if you have 2 contracts, if you're the buyer, you may owe 2 commissions. So if that answer is yes, find out, and it should not be yes, but make sure you understand why it's yes, and that may, you may have to go see your broker, because it may be some issues. So that should be, if it's yes, just know that's a red flag until you can understand why that answer is yes. All right. Starting date.
Otherwise, Joe, you get so pissed off and taking out the niece. Niece we call me up, I'm bringing to the office.
Trent, is there a form for the buyer and seller to authorize dual agency? And I think I missed that part of your presentation.
Now, there is no form. I just created a form in my office.
Okay.
There is no form that PAR has. I know a lot of brokers have created a form, but if not, just do an addendum.
Okay.
Just do a simple addendum saying that the buyer and seller agreed to have this agent represent both parties in this transaction, and have them sign it, just to protect yourself.
Okay. Okay, yeah, Trent, thanks a lot. Thank you.
You're welcome. All right, so let's look at the start and end date. Obviously, it says no association of realtors has set or recommended to terminate this contract or have discussed and agreed upon the length. So in other words, every contract, the end date, the fees are all are negotiated by the client and the brokerage. So no, you can't have an outside organization like GPAR or NARs recommending termination dates or length of contracts or commissions or fees. It is all negotiated between that company and that client. And here's one that I like to point out to buyers. Look at the last sentence in A1, 1A. It says, even though the broker's fee or a portion of it may be paid by a seller or listing broker, the broker will continue to represent the interests of the buyer. Sometimes first-time home buyers think, well, wait a minute, if the seller is paying the commission and you're representing me, then you're more loyal to the seller. Well, you point out that it does not matter who pays my commission. I am loyal to you. It doesn't matter if Santa Claus pays my commission. This buyer agency contract is between my company and you, and my loyalties lie only with you. It doesn't matter who pays. My loyalty does not lie with anyone else. Anybody can pay the commission, but the person who you enter into a contract with is the one that you owe the loyalty to. You owe the loyalty to. So I've had many buyers over the years think that if I'm being paid by the seller, somehow I'm going to do things to undermine their bargaining position, or I'm going to try to get the best deal for the seller. I tell buyers, it does not matter. I'm always looking out for your best interest, not the best interest of the seller. It does not matter who pays the commission. My interest lies with you and you only. B, it says that I just mentioned that the buyer will not, and you point out to a buyer in this buyer agency contract, you cannot enter into another one. You should not enter into another. It says you will not enter into another one, but buyers could enter into another buyer agency contract, but they just may owe someone 2 commissions. And I would explain, if you enter into another one, then you may be responsible for 2 commissions. You don't want to enter into another. This says you agree not to enter into another buyer agency contract, and it would be in your best interest not to. All right. The end date, the start date, if this contract starts at the date that it was signed, you don't have to put anything. But if it's a different date, if you're going to sign the buyer agency contract today and it won't start until Monday, then you will put Monday's date. But otherwise, it starts after the last party has signed, when it's been fully executed. One of the things I tell my agents, always let the buyer sign first. Let the buyer sign it, because now when you, the agent, the licensee signs it, then you know it becomes binding as of that date. You kind of know, I like to know dates, because maybe I can't understand if this buyer signed it on the 14th or the 16th. Well, I know when the agent signed on the 17th, this contract becomes binding on the 17th. Because if you put in this contract, for instance, that it ends in 3 months from the date of this contract, then you may be 2 or 3 days off. By the way, I wouldn't even do that. Take a look at where it says this contract ends. Don't put 3 months from today. Put a date. It ends September 30th. It's always, it can be a little confusing when you start trying to figure out when the document was fully executed. Put a date and you don't have a problem. This contract ends September 30, 2021, not 45 days from the date this contract was signed. And then we don't know if it was signed on the July 14th or July 15th or July 16th. This contract ends September 30, 2021, no issues. All right. And C is always, I found once, I thought this was funny, but C, look, it says a buyer is negotiating or has entered into an agreement to sell, this contract ends upon settlement. I remember years ago, there was an agent, a buyer has signed a buyer agency contract that went on for maybe 10 months, extended for 10 months. And the buyer bought the property. And then this buyer went to another office and bought 2 more properties. And the agent thought or filed some kind of claim because he said the buyer owed him a commission because he bought more properties during the term of this contract. That's why that's there. It's clear. This contract ends if the buyer is negotiating or has entered an agreement to sell. This contract ends upon settlement. Once you find a property for a buyer, and if today is settlement, this contract is over as of the date of settlement. It does not, even though it, according to the buyer agency contract, it expires, let's say September 30th. Well, the settlement was July 16th. It ends today. So if the buyer goes out and buys additional properties, that buyer does not owe you a commission. And I've seen a couple of buyer agencies think that that was the case. That is not the case. All right. Any questions? Comments?
Yeah, we got a question a few minutes ago from Lisa, and she's asking, can we not request a termination in writing within 24 hours for the buyer agency contract if it is for an extended period of time?
Can we? I mean, you can put that in it. That's not here. So the answer is no, but could you do it? You would put, and I was actually going to mention, I would put, if you want to be able to terminate this contract, I would put it, if you go to page, look at the last page under additional terms, and I've done this before in additional terms. What I would do, if I've said to buyers, if you want to terminate this contract, all you have to do is give me 24 hours notice or 48 hours notice, but I could do the same. Either one of us could terminate this contract by giving the other party 48 hours notice. Yeah, you could put that in the contract. Absolutely. And I think buyers feel better about that, knowing that, hey, maybe I don't think you're the right agent. So I want to be able to terminate it. So yes, I would absolutely do that. I would say a buyer, hey, I'm gonna put in a termination clause. So if you want to terminate it, but obviously if I showed you the property, then I'm the procuring clause and that's something different. But if I want to terminate this contract, but if you want to do that, just put it under additional terms. That's all. But there is nothing in the buyer agency contract that allows a buyer to terminate you. It ends. There's an end date. That's when it terminates. If you want to terminate it before the end date, then specify it under additional terms. Was that it? Is there a point? Oh. All right. Look at paragraph 2, the broker's fee. Again, no broker's fees have been recommended by any organization, association, by another broker. Your fees, and even realtors and real estate folks ought to be careful when they're discussing fees with other licensees, other salespeople, other brokers. I don't discuss my pay structure with any other broker. That borders to me on, well, not borders, that could be a violation of federal or state violation of of antitrust. You don't want to be discussing what your office pays you with people in another office. I would stay clear of that. Well, I get 60-40 until I would just not do that. Well, I get 80, I don't discuss, and I don't have those discussions. Whatever your office agrees to give you as a split or however you pay, that's between your broker and you. And it should stay in that office, not go and not be discussed with other offices. So just be careful about that. I know agents do it all the time. Trust me, I hear it all the time. This is what I get paid. And if I interview an agent, I don't ask them what their previous broker paid them. I don't care. This is what I'm offering you. The two of us will negotiate, okay, a fee. It's not based on what someone else already paid you. All right. B, look at 2B. It says your fee will be broker's fee paid by the buyer to the broker is as follows. In a purchase transaction with the seller. Well, let's look at one is if the seller has an agent, and 2 would be if I'm sorry. 1A is if the seller is represented by a real estate agent. B would be if it's not represented by a real estate agent. Otherwise, B would be a FSBO. But let's concentrate on A. Here's what another thing that I see mistakes here. With a seller, a fee is earned according to this. With a seller represented by a real estate agent or real estate broker, the fee is blank, whatever the fee may be. Let's say the listing agent is offering 4% commission to a buyer agent, but you want 5%. So you put in here that the fee for that buyer is 5%. Well, there's a difference of 1%. So that buyer will owe your company 1%. So you need to make sure that your buyer understands that if there's a difference and they have to pay it, they understand that they owe that. Don't wait till you get the settlement to tell a buyer, by the way, you owe $1,500 commission. Again, whatever your policy is in your office is, you need to check with your broker. Your broker may say if they're accepting 4%, we would take that and not charge the buyer 5%. But again, that's an office policy decision. But take a look at this and if with the B1A, in a purchase transaction with a seller represented by a real estate broker, the fee is, let's say, 5% of the purchase price or whatever. But you're charging them, let's say they said 4%, but you charge them 5%. Take a look at the paragraph, look at B3, I'm sorry. 2B3, it says it is a broker's policy to accept compensation offered by the listing broker if the amount received from the listing broker is less than the amount in that paragraph in a purchase transaction. The buyer will pay broker the difference. So you make sure you understand that a buyer understands, or you point that out to a buyer if the buyer has to pay a difference between what the seller's agent, the seller is offering your office, and what the buyer is expected to pay your office. If those numbers are different, please make sure the buyer fully understands that, because buyers will not be happy if they learn that they owe thousands of dollars possibly at the end of this transaction. And I've seen that happen. Make sure if that's the case, you point that out to the buyer and let them know that, hey, we want a commission. My office has a minimum commission of 5%. 5%, and this seller's only offering 4%. So you're responsible for the other 1%. Make sure they understand that. Any questions or comments? How are we doing so far? Nothing. You all sleeping? Anybody on? Can you all not hear me?
Good.
You are not sleeping. We're all good.
We're awake. We're awake.
All right. I just wanted to make sure. I see Cheryl sleeping. I didn't know if anybody else is sleeping. All right. All right. Look at the.
Hey, Trent?
Yes.
I have a quick question. So with 2B1A, so I had a buyer who is a friend of mine decide, you know what, this language doesn't sound right to me. It still sounds like in 2B that the fee is paid by the buyer to broker, and he decided not to sign this because even though I explained to him in 1A, the seller pays a commission, he thought the language in letter B was still stating that he's going to be responsible. There was no way I could further break it down than what was here. Any suggestions on that?
Well, wait a minute. Was the seller represented by a broker?
Yes.
All right, but then B does not apply.
That's what I was trying to say. Yeah.
You could have crossed out B. It made it easy. Look at B1, which is B1B. It says in a purchase transaction with a seller who is not represented by a real estate broker. So that's a FSBO. That's only if the seller does not have a broker. So what I would have done, I would have crossed it out and had them initial and say, this does not even apply to you because the broker is represented by the seller is represented by a broker. This only talks about a seller who is not represented by a broker. This is the seller's a FSBO, and so this doesn't apply. So I would have just crossed it out.
Yeah, that's kind of what happened. I guess, buyers read, they Google, and he still just thought, you know what, even though you crossed it out, I'm not comfortable with that because I don't want to get stuck paying anyone's commission. We parted ways. But I just thought it was something that I wasn't explaining right. So I just kind of wanted to know your thoughts.
If you cross it out and you explain it and the buyer still says, I'm not comfortable, I don't know what else you could do because you cross it out. You're saying it doesn't even apply to you.
Right.
So
you could try, excuse me. Yeah, you could try and maybe just write that the buyer will not be responsible to pay any commission whatsoever. So it's right there for him.
And that's a good, and Robbie, I would agree.
Extra step. Thank you.
And you could just write that additional terms. Absolutely, I agree with Robbie. Just write in there in all bold that the buyer is not responsible for any additional commission or fees, period.
Got it.
And then if that doesn't work, I don't know what, then you tell them, I don't know what you tell them. All right, let's take a look at.
Thanks, guys.
Let's look at D, 2D, where it says that if a buyer enters an agreement of sale for a property after the end date of this contract, the buyer will pay the broker fee if the agreement of sale is a result of the broker's actions during the term of this contract. Basically, the broker is a procuring cause. If the broker negotiated, if you, on behalf of the broker, negotiated a deal, this contract with the seller, and this contract ends today, and that buyer buys that property tomorrow, then you would be entitled to a commission because it was your work that got this property for the buyer. And this is what we call a broker protection clause. It protects the brokers from not being paid his or her commission after doing the work. 2, the property was seen during the term of this contract, and the buyer is not under an exclusive buyer agency with another office. So I have a few issues with that, but I'm gonna move on. Number 3, let's talk about dual agency. We already said that the buyer agrees that the broker and the broker's licensee stated above may also represent both the parties in this transaction. And here's what a lot of agents don't know, but it says, and that's what I was saying earlier, it says a broker is a dual agent when a broker, meaning the company, a broker, the company, is a dual agent when that company represents both the buyer and the seller in the same transaction. All right, so that company, if it's Weichert representing the buyer and the seller, Weichert is, these 2 licensees are dual agents. The company is a dual agent. And if a licensee, that salesperson or that associate broker is a dual agent, when that person represents both the seller and the buyer in the same transaction. So if you represent both the buyer and the seller, you're a dual agent. If your company represents both the buyer and the seller in the same transaction, you're also a dual agent. And remember, everybody in the office would be dual agents. Whoever you represent, everyone in your office represents the same person. What did I just say? What do you normally write in 2B? 2B, broker's fee in case of B. If you go back to, somebody had a question, go back to 2B2.
Right, come straight back.
Broker's fee in event of a lease transaction is, again, I can't tell you what I write in. It depends on, because every fee is negotiable and depends on your broker. But what would I put in? And I think I'm glad you mentioned that. Even if your buyer is not, and I skipped over that and I apologize. Even if your buyer is not looking for an apartment, looking to rent, what if your buyer decides they want to rent this house later? The seller decides not to sell, they rent. You don't have a buyer, you have a buyer agency contract that could also be used as a tenant agency contract. I would put in there whatever my fee is. If I want 1/2 of the month's rent or 1 month's rent, whatever your fee is in your office, I would write that on 2B2. Buyer's fee in an event of a lease transaction is whatever you say, 1 month's rent, 1/2 month's rent, 1/3 month's rent, whatever it is. I would just write in whatever. My office has a certain fee that we charge people who rent. So I would put that fee in there. So thank you for pointing that out. All right, take a look at
Question.
Yes.
On the broker fee, back up. So broker fee B, and then it says all the way at the end, percentage of the sales price or dollar amount, whatever, whichever is greater end. What is the box there at the end used for?
If your office has other fees, like some offices may charge a broker service fee or conveyancing fee. Whatever fee your office charges to a buyer, it must be disclosed. So that's where you would disclose it.
Perfect. That's the answer I was looking for. Thank you so much.
Yeah. If your broker doesn't charge anything else, then you put NA or put 0. But again, don't ever leave it blank, because blank means nothing to me. I don't know if you meant to leave it blank, it's supposed to be 0, or you forgot to fill it in. Never leave spaces blank. Put NA, put 0. Let someone know that you didn't skip that question by mistake make sure you put an NA if it does not apply.
So in all these boxes, correct? Put a 0 or NA?
I would put, if they don't apply, I usually put NA or 0, whatever. Yeah, I don't leave things blank because you don't know. I mean, you don't know if that, and then I go back and say, oh, I forgot to fill this in. I don't know. And I tell my agents, did you forget to fill this? I ask them, did you forget to fill this out or did you mean to leave it blank? Half the time they forgot to fill it out. So, you know, so if you put NA, I know it doesn't apply. If you put 0, I know it's 0. So I just think it's better to just not leave things blank. All right, go back to dual number 4, designated agency. Again, if your office practices designated agency, then this applies. If it does not, then you would check the designated agency is not applicable. But again, that's up to, you know, you have to find out if your office practices designated agency or not. If you don't practice, oh, by the way, if you don't practice dual agency, then you would use the form, the single agency form. If you look on the back, look on the paragraph, look on the back last page under special clauses where it says the following are part of this buyer agency contract. I think we may have it up, is a single agency addendum. If you'll check that, include that single agency addendum, that is only if your office does not practice dual agency. All right, you only will represent one party or another, but not both. So then you would use that. I don't know, a lot of offices don't practice dual agency, but if your office does not, then use a single agency form. All right, paragraph 5, broker services to others. This is about being loyal to your client. A says broker may not take action that is inconsistent with the buyer's interest. I think this is clear, but I think agents sometimes do things that are not in the best interest of their client. I just recently, I saw there was an agent in an office who bought a property. His seller he listed a property. Well, let me just give you some, he listed a property for $100,000. The property after renovations, you'll probably need about 75, I think he said, to put into it. And he was going to sell it for about $325 or $350. So he decided to buy it for $50,000. I don't think that's in the best interest of your client for you to buy a property that they hired you to sell for them at a low price so that you can benefit from all the equity. You should always act only in the best interest of your client. I'm sure we've all, I remember when I first started this business and I got a call from someone in Chestnut Hill. This woman wanted to sell her house. She told me she wanted $50,000. Keep in mind, this is 25 years ago. She wanted $50,000 for a house that was in bad condition, but it was a 4-bedroom house, single, with a 2-car garage. And she wanted, I think she said 50 or 75,000. Well, I sold it for 400,000. Now, could I have gone and bought it for 50 or 75,000? Some agents would have, but I would think that you breached your fiduciary duty of loyalty, because when that woman called on me, she called on a real estate professional who would give her would tell her the true value of her property and not take advantage and turn around, sell it to an investor or keep it him or herself and make the money. Because I believe the money that you make off of a situation like that belongs to that seller and not to you. But, all right, but, you know. All right, 5B, and I've seen, and I bet you somebody else would agree, that sometimes buyers think that, well, let's read it. It says broker licensee may show the same properties to other buyers and may represent those buyers in attempts to purchase the same property that the buyer wishes to purchase. Broker does not breach a duty to buyer by showing a property buyer is interested in to other prospective buyers. I've had buyers say to me, but wait a minute, you showing the same house to other buyers? I said, well, yeah, I'm showing it to other clients who are interested. Some buyers think that if you are representing them, you shouldn't be showing the house that they like or writing up an offer. Sometimes I remember once writing up 3 offers, 3 different buyers on the same property. They're like, well, that doesn't sound fair. You're supposed to be representing me. I am representing you. you tell me what you want to offer. I'm not going to share what you're going to offer with anybody else. So all you do is give me you tell me what you want to offer. And so sometimes, so you let them know that even though I'm representing you, I have other buyers I may show that same property too. And it's not a breach of my fiduciary duties to you.
That's interesting, Trent. Yeah, that brings up a interesting area there. Your loyalty to the multiple buyers.
But remember though, Rob, I don't say to you what you should offer. I ask you what you want to offer. I give you comps. I talk to you. I give you facts. I never tell a person what you should offer. I never say you should offer 300,000. I would say to you, this is kind of market we're in. This is how long this property's been on the market. This is the condition. We walked in, we have 4 other people waiting to get in. So with, all of I'm giving you the facts. Now you tell me what you want to offer, because I'm not going to say, well, I think you should offer X, because I'm going to tell you, knowing I'm giving you the information, you make the decision. Now, if you say, I like to offer 75,000, then I say you're crazy. Now I say, I am not writing that up. All right, I'll tell you that. I'm not writing that up. But, but I'm not going to tell you what you should offer. All right,
Can I make a comment, Trent, please?
Yes, absolutely.
There is a little bit of a conflict here, because when you have these 3 buyers, then you are in a bidding war, and the seller's agent comes back to all the agents, and you are representing 3 of the 8 offers, for example. You are kind of aware, you are definitely aware of what's going on each side. And then one of your sets of buyers is telling you, so we have offered 200,000 at this point. How much do you think we should offer to win? When you know that buyers number 2 have offered, already 25 grand more than buyers number 1, etc., etc.
Let me say this. If that situation happened, I would give it to another agent to represent. When I did that, it was a house that had been around for a long time, and it was nothing like that. But if what you just said, and I have a policy in my office that if you're the agent and you're representing the seller, and you also have a buyer, if you're the seller's agent, but you also have a buyer, and we have multiple offers, I have to get all the offers. You can't see any of the offers. They must come to me, the broker, and I will present them to the seller. Because I don't think that you as an agent, if you represent the seller and you also writing up an offer yourself, which is fine, but all the other offers that come in, I'm not gonna let you see them. They come to me, and I will present the offers to the seller, and I will because I do think it's a lot if you have the seller's agent, you represent the seller, you writing up an offer, and then you got multiple offers coming in, and you have to decide which is, you have to present those offers. So, but in that situation, I would never be in a situation where I'm having three offers and somebody's coming back and saying, give me your best and final. I would give it to one of my associate brokers and say, you take one, you take these, I'll have one, I'll just represent the seller or my buyer, and you all have the other 2.
Mm-hmm.
To avoid, I do anything to avoid anything that would not help my buyer. In that case, I think that's too much with 3. But again, when I did that, one of them offered, I just tell you, one of them offered like 200, other offered like 100, other offered like 110. Okay. So it was not even like it was a buyer's market, and it was a property been around for 6 months.
Okay.
All right. Let's go back to the entire contract. Go to paragraph 6. I'll go to 5C. It says it's the conflict of interest when a broker or licensee has a financial or personal interest in the property and cannot put the buyer's interest before any other. So when you have a conflict, you need to disclose that to the seller. You should not be, again, I remember once years ago, a agent buys a property, every 18th and Diamond, 3-story, 2,200 square foot, buys it for $25,000, turns around, sells it the next day for $350,000. But he's representing the seller. He says to the seller, I'll buy it. Next day, he turns around, sells it to an investor for 3 something. Investor then puts 200 and sells it for $1 million. That's obviously not that acting in the best interest of the seller. Sellers. Now, well, let's talk a minute about your fiduciary duties to a client, in this case, a buyer. I always teach it as an old car. You owe 6 fiduciary duties or responsibilities to every buyer, and I call it an old car. You owe them. O would be obedience. You have to obey their instructions. You obviously don't obey illegal instructions. You can't say, don't show me properties where Muslims live, or where Jewish folks live, or where gays or lesbians or blacks. You don't obey illegal instructions. But if they say, only show me houses that have been on the market less than 5 days, I mean, that, don't show them property. I mean, that's probably not a great example, but obey the instructions. All right. If they, let's say if they say, I don't want to show a house where an animal lives, a dog or a cat, because I'm allergic, then you need to obey those instructions. You don't then decide, I know a dog's there, but it's a great house for my client. Obey the instructions of your client. L would be loyalty. We talked about loyalty. You need to put your interests above the interests of everybody, including yourself. Your client's interests are paramount and everybody else's are secondary. Never put your client's interests below anyone else's interests. And D would be disclosure. You need to disclose to your client anything that you know about that house or that area. If I know that they're about to build a prison on the next block, I should disclose that to this buyer. I don't have to go do research in the neighborhood, but if I know that they're building a prison on the next block, and it may affect the value of this property, I should disclose it. Just like if I know they're about to build high-end luxury condos on the next block, I should disclose that. I should disclose anything I know about this property. If I know next door is a crack house, I mean, I should disclose it if I know it. No one says you have to go around and do research, but you disclose to your agent, to your client, whatever you know, be it good or bad. C for old car, OLD. C would be confidentiality. Clearly, you owe all your clients confidentiality that lasts forever. You cannot disclose anything that you learn from your client. You can't disclose it to anyone else. Confidentiality lasts forever. It doesn't end after this contract ends or at the settlement table. It ends. It lasts forever. A would be accounting. You have to account for the money that your client gives you. If your client gives you deposit money, that money needs to be turned over to your broker immediately. That broker must put that money into his or her escrow deposit by the end of the next business day. So you need to account for your client's money. And R, to make it an old car, would be a reasonable degree of care. You owe your client a reasonable degree of care. They're coming to you as an expert, as a real estate professional. You should know more about real estate than the average person. And what you don't know, you should ask. And for newer agents, I always tell new agents that if you don't know something, you have cell phones. You tell your buyer or that client, well, I may not know, because sometimes clients will say to you, well, you're new, and so I don't want to give you this listing, or I don't want to work with you because you've only just started. Well, I say, well, you know what? I'm on a team, and my team has 10 people, and together they make up 200 years of experience. And so I may not know the answer, Gabriella, but I'm one phone call away from getting the answer. Period. Don't let people intimidate you because you're new. You can get the answer. And people respect that. People know that you have to start somewhere. Don't ever give someone an answer that you don't know is true. Don't make up an answer because you're nervous. Say, I don't know. People respect that you don't know, but you say, I will get you the answer. But don't just say, oh yeah, the answer is X. And then they're like, well, wait a minute. This is not true. Or this is wrong. And now you lost all credibility and you're going to lose the client. All right. Number 6 is the entire contract. This says that this contract is an entire agreement between the buyer and the broker. Any verbal or written agreements that were made before, they are not a part of this. So if your client, you made some agreement, like let's say your buyer said, hey, I want a cancellation clause. And you said, listen, you can cancel anytime. Well, that's not a part of this unless you make it a part of this. Then it's not a part of this agreement. So any agreements that you make put them in this contract. All right. The transfer of this contract, 7, just basically says that the broker can transfer this contract to another office if he or she stopped doing business, or if they formed a new company, they can transfer this contract or take this contract with them. Confidentiality, we just talked about. Paragraph 8, it says, unless permitted by the buyer or required by law, the broker will not knowingly reveal or use any confidential information of the buyer, because confidentiality lasts forever. Buyer understands that the seller or the seller's representatives might not treat, this I think is a key here. Buyer understands that seller's representatives may not treat the existence, terms, or conditions of any offer as confidential unless there is a confidentiality agreement between the buyer and the seller. Keep in mind, when you submit an offer, when your buyer submits an offer, and I tell my buyers this, the seller can reveal anything that he or she wants about that offer to anybody. That offer is not confidential. So if the buyer, you submit an offer, the buyer could say to the next agent, hey, I got an offer from John Smith for 300,000, but he's got a, his credit doesn't look all that great, or he's got an FHA. The seller can reveal whatever he or she wants about your offer. I don't recommend you do that. I wouldn't do that, but they could. So let buyers know that when they present an offer to a seller, that offer is not confidential. The seller can reveal anything about that offer they want to whomever they want. This is not unless you have some confidentiality agreement that says they cannot reveal anything about your offer. And I bet your seller wouldn't even sign that. But I just know that, just let them know that their offer is not confidential. Sometimes people think that, how can they tell another agent that my offer was 2025? Because they can. And so then you say, hey, I got an offer from John Smith for 2025. Can you beat that? Yeah, I'll give you 2026. Okay, that's it. All right. Expertise, number 9, expertise of the real estate agent. Remember that agents are not experts in, and I say in law, accounting, or science. We should be experts in real estate. Anything outside of real estate, you should know your lane. Refer people to the experts. Don't try to be an expert in a field where you're not. All right. And if you just look at 9A, it says if buyer wants information regarding specific conditions or components of a property which are outside brokers or licensees' area of expertise, the buyer is encouraged to seek the advice of an appropriate professional. And B says if buyer wants financial, legal, or any other advice, buyer is encouraged to seek the services of an accountant, a lawyer, or other appropriate professionals. You are an expert in real estate, not in law, accounting, or science. Number 10, deposit monies. Broker will keep deposit monies in an escrow account as he or she must, as required by the real estate licensing laws, until the sale is completed or an agreement sale is terminated. Now, if you as the agent receive a deposit money, a deposit, earnest money deposit, and you intend to turn it over to the listing agent, then you must have that buyer, by law, you must have that buyer sign something, and we use a deposit money form, a deposit money notice saying where my money, who will be holding my money. You must have that buyer sign something, and you can just use the deposit money notice that says that Keller Williams will be holding my money. I'm writing a check, even though I'm writing a check payable to Keller Williams, but I'm giving it to you, and you're at Berkshire. So I need to know who is holding on to my money. So you need to sign, they have to sign a deposit money notice or some other notice that says who will hold this money in an escrow account. All right. Until the sale is terminated or the terms of a prior written agreement between the buyer and the seller been met. Just keep in mind, tell your buyers, because this has happened and probably happened to all of us. Make sure your buyers know that if there is a dispute, your money cannot be released unless, well, let's look at it, unless buyer and seller Let's say, the terms of a prior agreement, buyer and seller may name a non-like, well, let me come back to that last. Let me finish that sentence because there's something else I want to show you. Let me go back and finish reading that. It says, so deposit monies must be kept in a, I'm sorry, broker will keep all deposit monies received in an escrow account as required by the real estate licensing laws until the sale is completed or an agreement sale is terminated, or the terms of a prior written agreement between the buyer and the seller have been met. And that prior written agreement is put in there is paragraph 26C. That's that prior written agreement that says that if there is a dispute with that and it's not resolved within a certain number of days, if it's not resolved, then if the buyer submits a letter to the broker, that broker must give that deposit over to the buyer within 30 days if that seller has not initiated litigation or mediation. Well, let me read it to you. Let me see so that prior written agreement is in your agreement of sale, paragraph 26C. And it says exactly, it says buyer and the seller agree that if there is a dispute over the entitlement to deposit monies that is unresolved and you have to put the number of days, let's say 30 days. Buyer and seller agree that if there is a dispute over the entitlement to deposit monies that is unresolved 30 days after the settlement date or following termination of the agreement, whichever is earlier, then the broker holding deposit monies will, within 30 days of receipt of buyer's written request, distribute the deposit monies to buyer unless the broker is in receipt of verifiable written notice that the dispute is a subject of litigation or mediation. So if there is ever a dispute, that's why in that paragraph 26C, don't leave it the way it is now is 180 days. Put 30 days, 20 days, 15 days, because if you let 30 days, after 30 days, if there's a dispute, you can, and the seller has not initiated mediation or litigation, and you submit a letter to that broker has within 30 days to return that deposit money to you. Now, it also says at the end of that paragraph that because even though the broker returned the money to you, the seller could, well, let me just read it. It does not mean that the seller cannot come back and try to get the money. The last line there says, buyer and seller agree that the distribution of deposit monies, the broker has given that money back to you. The buyer and seller agree that the distribution of deposit monies based upon the passage of time does not legally determine entitlement to deposit monies, that the parties maintain their legal rights to pursue litigation even after a distribution is made. So even if this broker gives the money to the buyer, the seller can then still come back later and file a lawsuit. But the fact is, you will have the money in your possession, and most sellers are probably not going to do it. All right. Any questions? Then it goes on to say a buyer and a seller may name a non-licensee as the escrow holder. Well, the non-licensee would be a title company or an attorney. A non-licensee, I talked about this last week in agreement sales seminar. I don't like having a non-licensee holding deposit monies because they're not held to the same standards as a broker. Broker knows what he or she must do before that broker can give that money to anyone. But if you're an attorney holding it, or you're a title company holding deposit money, you're not held to the, you're not bound by the Real Estate License and Registration Act or the Pennsylvania rules and the rules and regulations of the Pennsylvania Real Estate Commission. You are bound by the escrow agreement between the title company and or the lawyer and the parties. But so you need to know if an escrow company, if a title company or an attorney is holding the escrow, you need to know what happens if there is a dispute. Make sure you understand what's in that escrow agreement, because the escrow agreement may say if there's a dispute, we get to determine who we think is entitled to the money. And so what if they think the buyer's entitled, the seller's entitled, and they're like, wait a minute, I don't believe that. But a broker can't make that decision. When there is a dispute over escrow monies, the only way the broker can distribute that money, and take a look at it. Let's look at B. It says, regardless of the apparent entitlement, no matter who I think you're right or you're wrong, I can't determine who gets that money. Regardless of the apparent entitlement to deposit monies, Pennsylvania law does not allow a broker hold the deposit monies to determine who is entitled to the deposit money when settlement does not occur. One, it says broker can only release deposit monies, one, if an agreement of sale is terminated prior to settlement and there is no dispute. In other words, let's say you buying a property, buyer says, the buyer does a home inspection, buyer says, you know what? I don't like the results of the home inspection. I'm gonna back out. I'm gonna terminate the agreement sale. You can do that. And as long as the seller is not disputing it and you use that, make sure you use the form termination of agreement of sale. Make sure you don't use the 2-1. People get them confused. Use a notice of termination of agreement of sale if you terminate an agreement of sale based on the home inspection. Do not use the agreement of sale release. Agents confuse these two. If you have a buyer, you do a home inspection, buyer says, too many issues with that property, I don't want it. Send the seller's agent a notice of termination of agreement of sale. Do not use the agreement of sale release, because when you use a notice of termination, the only person who has to sign is your buyer, the person terminating the contract. Both parties don't need to sign a notice of termination. But if you use the agreement of sale release, both parties need to sign. You don't need to send a notice of, just send a notice of termination, because the agreement of sale gives the buyer the right to terminate the contract if he or she is not happy with the results of the home inspection. All right, so make sure if there is but yes, let's do that. Use the notice of termination. All right, let's go back to B2. It says the broker can release the money. One was only if did someone say something?
Yeah, it's me. Sorry, I have a quick question. You explained this before, but I think it was still a bit cloudy. So without using the termination of release, like for deposit, if we just use that single form, then are we able to submit just that to just say the title company or the brokerage so that they then will release the deposit? Because I thought you had to use the other form so that you could have the deposit released.
No, you only need the notice of termination. Keep in mind on this time, but we're talking specifically with not everything, but with the example I gave, which is the biggest. I mean, in other words, if your buyer does not want to buy this property because of the home inspection report, you don't need the seller to agree to return the money. The agreement sale says
the agreement.
Right. The agreement sale says the buyer can terminate this contract if he is or she is not happy with the results of the home inspection report. This is the only form you need. If you use a notice of the agreement sale release, the buyer, the seller has to sign. When you send a notice of termination to the broker for the seller, that broker for the seller should just release that earnest money deposit. You don't need that one, because you don't need the seller to sign off on this. The seller, the agreement sale gives you the right to terminate this. It doesn't say that the seller has to agree. Now, if the seller has an issue with it, then that's a different story.
Got it. I remember it does say it in the agreement of sale.
Yeah, I would just, as a broker, would just release it, because I would say to the seller, hey, they have the right to release it. I mean, to terminate it. But if the seller said to me before I did it, do not release that money, then I wouldn't. If the seller's like, then I wouldn't. But I wouldn't even ask the seller. I wouldn't even ask the seller.
Here's my final question. I think I mentioned this before, but in another Zoom, but this trend with title companies holding deposit monies, what if an agent says, hey, we're not holding any monies? I know, like with my office, we say that, but what if you don't want the title company for this very reason? You know, because
it's right. I wouldn't have a title company hold money. I wouldn't. Then what you do, let the other office hold it. There are a lot of times.
What if they say they don't want to hold it?
Of who doesn't want to hold it?
If the listing agent's office says
then you hold it. Then ask your broker to hold it. You can hold it. Your broker can hold it. I get a lot of company. I mean, I may be the buyer's agent, and I have a lot of companies that say, hey, we don't hold escrow. Can you hold it? And I'll say, sure. But I don't want a title company holding it. I don't want a lawyer holding it. I'd rather hold it. Let the other office hold. There are two companies involved. If one didn't want to hold it, Ask the other company to hold it.
Gotcha. Thanks, Trent.
You're welcome. All right, go back to B, where it says a broker can release the deposit money again. One, if the agreement of sale is terminated, when there's no dispute, like with involving a home inspection. Two, broker receives a written notice that is signed by the buyer and the seller, directing them how to distribute the money. Well, maybe the buyer breached the contract, but the buyer says, you know what? Yeah, I'm wrong. I'll turn up. I'm willing to give the seller half the money. Seller says, I'm okay with that. And then you sign, then you do this, sign that agreement of sale release, and it said, and distribution of funds. And it says, okay, in this example, all right, it's $20,000 escrow. Buyer gets 10, seller gets 10. You sign that and you tell the broker how to distribute so the broker can release that money because he has an agreement from the buyer and the seller. It says you can release this money. We both agreed to it, agreed on it. And three, according to the terms of a final order of court. If you have an order by order of a court, the broker can then release it because the court says, hey, release this money to the seller or release this money to the broker. Then as a broker, release this money to the buyer or release this money to the seller as a broker, then I'm obligated to do that. And four, according to the terms of a prior written agreement. Again, that is that paragraph 26C. According to the terms of a prior written agreement between the buyer and the seller, directs the broker how to distribute the deposit monies if there is a dispute. Remember, that paragraph 26C talks about if there's a dispute. What do I do if I'm the broker and there's a dispute, who's entitled to the deposit money? Well, I can't decide, but paragraph 26 is a prior written agreement that says if there is a dispute that's unresolved within, let's say, for example, 30 days, then this is what can happen. All right. Paragraph 11, Civil Rights Acts. This is close to dear to my heart. You should never, ever, ever take a listen where a seller or a buyer or any client or customer is telling you to discriminate. Let's just read it because it just needs to be heard. It says federal and state laws make it illegal for a seller, a broker, or anyone to use race, color, religion, or religious creed, sex, disability, mental or physical, familial status, children under 18 years of age, or you could add in a pregnant woman, age 40 or older in the Commonwealth of Pennsylvania, national origin, use of handling, training of support animals, or the fact of relationship or association to an individual known to have a disability as reason for refusing to sell, show, or rent properties, loan money, or set deposit amounts, or as reasons for any decision relating to the sale or rental of property. If someone tells you to discriminate, you need to walk away. I'd always say no amount of commission is worth your freedom. You losing your freedom. And one time, and a lot of times in my career, I see families with children. People still seem to think that it is okay to discriminate against families with children. That's the one time I hear so often, I don't want children upstairs on the second floor because my first floor tenant may move out if they're children. People don't think that, and I have to remind them that's a violation of fair housing, federal, state, and city. You can't not put a family with children on a certain, you can't limit family with children to a certain floor in a building. If they want second floor or third floor and they qualify, then they have to get it. You can't decide, because that we all know from real estate fundamentals is called steering or practice. That is steering. You can't steer families with children into certain buildings or certain floors. They get to choose where they want to live. So that's clear. If someone tells you that they're not going to, they want you to discriminate against people who are in the protected class, then you need to walk away. And I wouldn't say walk away, I would say run away. Number 12, any questions, comments? Number 12, Megan's Law. This is mandated by state law that it be included in this document. So if you have buyers encouraged to contact the municipal police department or the Pennsylvania State Police for information relating to the presence of sex offenders near a particular property, or to check the information on the Pennsylvania State police web at www.pameganslaw.state.pa.us. Here's one thing you should never do. Don't ever check for your buyer. Don't ever check for your buyer. If your buyer says, I have young daughters and I want to make sure I'm not living near any sex offenders, can you make sure for me that no sex offenders are near this property? If you go on that website and you by chance miss the sex offender who's living next door, and then that sex offender harms one of those children, you're going to be included in a lawsuit. Don't ever check for a client. You can say, that's why this is here. You can say to your client, go to this website, call the police, the state police. Do not say, oh, there are no sex offenders on this block. I checked for you. You put that onus on them, let them check. Don't you ever check, because if you make the mistake, you're going to be the one liable. All right. Any questions, comments, anything? 13, buyer inspections. Remember, it says, unless buyer and seller agree otherwise, the real estate is sold in its present condition. You're buying property as is unless you agree to a home inspection. It is a buyer's responsibility to determine whether the condition of the property is satisfactory. Buyer is advised to carry out an inspection. So understand that your buyer understand that if that buyer is buying this property without a home inspection, this buyer is buying it as is. So you can't come back and say, oh, well, I didn't know, unless of course the seller didn't disclose something they should disclose, but you buying it in its present condition. You should get a home inspection if you have questions. Make sure you understand too, that if you have a seller's disclosure, don't ever have a buyer rely on a seller's disclosure in lieu of a home inspection. Sellers do not always disclose everything in a seller's disclosure, nor are they always completely honest. So if you get a seller's disclosure, you say, oh, boy, yeah, the roof is good, or the heater's relatively good. Well, then you find out that there are issues with both. Do a home inspection. Don't let your buyer take on seller's disclosure and then determine that he or she will not do a home inspection based on what the seller said. Or let's say you're in the house and the seller says, oh, the roof is good. The roof has never leaked the whole 20 years we've been here. Okay. I don't know what that means. I'm not going to rely on this. I want a roofer to tell me the roof is good. Unless you're a roofer and you can tell me that you've been up there and you're a licensed roofer, and then I may take your word, give me some documentation, give me some type of warranty. But otherwise, you don't want to let your buyer take the word of a seller or some document the seller gave to you. Rely on a home inspection, or have your own professionals go in and determine the condition, because you don't want your buyer to buy a property that will have issues.
Hey, Trent, can I ask a question?
Yes.
I haven't looked into this, but you know how now a buyer provides the inspection report at, when they're negotiating the inspection. But let's imagine that you are in a situation where the buyer is actually purchasing the property as is. They are doing an inspection, but it is not contingent upon the negotiation of that inspection. Do they have to provide that inspection report to the sellers nonetheless?
Yes.
They do, okay.
Anytime, and of course I disagree with, but the answer is yes. Anytime you do any inspections on a property, you must turn them the entire, it's the agreement sale says you must turn over the entire inspection report to the seller, whether they want it or not. You are mandated to turn over everything. And any other reports that you do, the seller is entitled to them. If the seller asks, you must turn them over. Gotcha. But the home inspection report, you must turn that over. That's why some sellers may say, you know what, I don't want you to do a home inspection if this agreement is not contingent upon a home inspection, because once you do it, you got to turn it over to me. And if this deal dies for some reason, I now have to turn that inspection report over to the new buyer, which may hurt me. But yes, you are obligated to turn that over.
Mm-hmm.
All right. We'll go back to, we're still on 13, buyer inspections. Look at B. Well, go ahead to buyer should discuss inspections. B, buyer is advised that information regarding properties considered for purchase by buyer has been provided by a seller or seller's broker. Such information may include, but is not limited to, the information on seller's property disclosure statement. So in other words, and it says, unless otherwise noted, last lines, broker has not verified the accuracy of this information. You don't know whether this information is accurate that the seller provided, and the buyer is advised to investigate its accuracy. Do not rely on this information from the seller. You make sure. That's why you have your own inspections done. Don't let your buyer rely on some comments that the seller made to her or him, or what the seller wrote in a seller's disclosure. All right, verify it yourself. All right, 14, recording of the property. You should not, nowadays, a lot of people have videos and recording devices. Just know that when you're on a property, they can't, it is against the law to record you or videotape you or record you without your permission, but you should be aware that people may be listening in on some of your conversations. I'm aware of that. I know it's happened in some house I've gone to. I don't have negotiations in a house anymore. I say, let's wait till we go outside. I don't know what the seller's listening to. I've gone to some houses that video cameras and everything. It was just so fancy and all kinds of technology. And I know the seller was, I know the agent was listening in. I do know that, because we went to a certain room and then he contacted me and said something about a closet floor. Don't forget, Trent, there's a closet or there's a bathroom. You missed that. So clearly they were watching. I just tell buyers, let's have the confidential negotiations outside of this house. All right. And look at 14, recordings on the property. It says any person who intentionally intercepts oral communications by electronic or other means without the consent of all parties is guilty of a felony under Pennsylvania law. Buyers should not make recordings on the property that capture the oral statements of other persons without having the full consent of all persons who are parties to the communication. B reads that buyers should be aware that a seller's property may contain smart home technologies or devices which may record or allow for remote monitoring of the seller's property, including broadcasting or recording video and audio. Buyers should be aware that any discussions, including discussions of negotiation strategies held on the property, may not be confidential. Don't hold those, hold your negotiations somewhere other than in someone's house, because I don't know who is listening. All right. 15, the recovery fund. Recovery fund. This disclosure is also required by the Real Estate License Registration Act and the rules and regulations of the State Real Estate Commission. It must be in most of our documents. The statement about the Real Estate Recovery Fund has to be an agreement sale, listed documents, buyer agency form. We have to, the Real Estate Recovery Fund, if you don't remember, if you represent a client and you engage in some type of fraudulent behavior at the time you're licensed, and the client sues and gets a judgment against you, tries to collect on that judgment and cannot collect on the judgment, then that buyer, that client can go to, within 1 year, they can come to the Real Estate Recovery Fund and ask for the money to be paid out of the fund. For every client, they can get up to 20,000. That's the max. And for every licensee, every salesperson is 100,000. So 5 people can come and if 5 different people had judgments against you for 20,000 each, then 5 people could get paid, because the maximum the state can pay out against one salesperson or associate broker or broker is 100,000. So if I got a judgment, if you got a judgment against me for 15,000 and I came and you couldn't collect against me, then you go to the Real Estate Recovery Fund, show proof that I was licensed at the time that this incident occurred. I may not be licensed now, and that you made all attempts to collect the money and you came to the Real Estate Recovery Fund within 1 year, then the Real Estate Recovery Fund would then pay you that 15,000. And once the Real Estate Recovery Fund pays any monies out for any licensee, then your license is automatically suspended until you pay all the money back plus 10% interest per year. I've never known the state to pay out any money on behalf of anybody, and I hope I never do. All right. And 16 would be special clauses. If you want to add in special clauses, this would be a good time where I said to put good place to put that cancellation clause or provision that says, if you say, hey, you want to, I'll allow you to terminate this buyer agency contract within, with 24 hours, 48-hour notice, or anything you want to put there, put that in the, or this would have been a good place to put that comment about you're not responsible for any other fees other than what you're not responsible for any commissions, if that client had some issues. All right, buyer has read, bottom of page, the last page, buyer has read and received the consumer notice. Make sure the buyer has a consumer notice. That's the first thing that you should have him or her sign. And remember, if it does not turn into a client, you must keep that consumer notice for at least 6 months. You must keep it for at least 6 months. Your broker must keep that consumer notice if it becomes a client for at least 3 years. All right. Buyer has read the entire. The buyer must sign this contract, and also remember that at the time this buyer signs, the Real Estate License and Registration Act requires that the buyer receive a copy of this at the time that that buyer signs, not tomorrow, not later on today. At the time that this contract is signed, the buyer must be given a copy of this contract. All right. And it says if the buyer is obtaining mortgage financing, the buyer shall promptly deliver to broker a copy of all loan estimate and closing disclosures upon receipt. Remember, the loan estimate, or LE we call it, is given to a buyer within 3 days of making a loan application. So make sure they tell them they need to give you a copy, because federal law will not allow the lender to give the real estate agent a copy of the loan estimate or the closing disclosure. Remember, the closing disclosure, or the CD, is given to the buyer 3 days before settlement. The law requires that this lender give that buyer or borrower a CD that has all the numbers that they need, all the closing costs need to be given to that buyer or borrower 3 days before settlement, but they cannot give it to us. It can only be given to the buyer. So that's why this is here. So the buyer knows when he or she gets that closing disclosure or that loan estimate, and they need to give you a copy. All right. And you did let them know that they won't give me the closing, the CD, and that's 3 days before settlement. When you get it, forward it to me. All right. And then go down there, it says notice before signing. If the buyer has legal questions, buyer is advised to consult a Pennsylvania real estate attorney. One thing I tell people, don't discourage a buyer if they have questions. Don't discourage them from seeking advice from an attorney. Don't say, oh, well, you don't need a lawyer. Oh, now this is easy. If they want to have a lawyer look at it, don't ever discourage a buyer from seeking the advice of an attorney. All right. If they have to, that's why that's all in caps. If they have problems, if they have questions, legal questions, then you should tell them, go get the advice of a lawyer and then come back to me. All right, buyer signs, make sure all the buyers on this contract sign and date. And again, you let the buyer sign first. And if you're in the office, you'll sign at the same time. But if you send it to them, let them sign it, then you sign it once it gets back. So you're certain of the execution date. You sign and date later. After it gets back. The broker, obviously that's the name of the company. And then your name would be, it would be accepted on behalf of the broker by, and that would be you or me. All right. And then that would be, I think that's the whole contract. We can talk about it now. I guess we can talk about any questions. We got a little bit more time. Did you all learn anything from that?
Yeah, a lot.
Always. Thank you, Trent.
Yes, we did.
There's 2 of y'all learned something, the other 30 of y'all didn't. How many people? So 2 people. So how many people on 36? So 34 of you didn't learn anything?
No, it was great.
3 people, Trent.
Oh, okay. 3 of you learned, 33 of you said.
Make that 4. 5.
4.
I could have been washing my car. Is that what Robbie's thinking? All right. Any questions or comments?
Mia, I would like to ask a question actually. So I've
Yeah.
been, practicing for almost 20 years and I have never used the form. I'm one of those dinosaurs. And I know I do need to change the way I practice. I see that I need to use this form, but I am wondering if amongst all the people that are part of the meeting right now, for those of you that have been using this form, when you get a little bit of pushback from your clients, what is the first sentence you use about this form? What do you tell them? Exactly like, the consumer notice, the very first thing we said, look, this is not a contract. This is just outlining what my fiduciary duties are to you. When you're presenting this form, what is the first sentence you say, just to break the ice and make sure that people are listening with an open mind? What do you guys say?
Hold on, Sophia. Let me just add something in there, and if anybody want to say anything, they can. But you remember one thing I said, you're not required to use a buyer agency form to provide services to a buyer, but you cannot be paid without a buyer agency form. If you don't have a buyer agency contract with a buyer, the Real Estate License Registration Act says that you're not entitled to collect a commission from that buyer. So you need to have it. You don't have to have it. You can have them sign it when they sign an agreement sale, but you should have, because remember the buyer agency contract is an employment contract between, they're employing you, they're hiring you to represent them to find a property. If you don't have a buyer agency contract, you have no employment contract. Therefore, you're not hired to represent the buyer, even though you can represent them. But because you don't have an employment contract, you're not able to be paid. So you have to have this at some point. Mm-hmm. So you want to start getting it, because without a buyer agency contract, the Real Estate License and Registration Act is clear. You cannot earn a commission from that buyer. Mm-hmm. And also, I would say this to you: if your buyer, and then anybody else want to add anything, if your buyer has resistance, what we said at the beginning, have them sign, and I think Lisa said it beautifully, have them sign a 1 day or she said one tour. You taking them on tour of 6 houses. It only covers those 6 houses, just that one tour, or it's only good for this weekend. And that's it. So if they give you any resistance, what I would say, okay, we'll make it. You want to see a particular house. It would only be for that one house. You can put in here, this contract is good only for 123 Main Street. That's it. If I show you 123 Main Street and you purchase it, then I earn a commission. If you purchase any other property, I don't have anything to do with it. You can go anywhere you want to show you any other properties, but if you purchase 123 Main Street, then I've earned a commission. That makes sense to you?
No, the whole thing completely makes sense. I completely understand the reason and the value of the document itself, but I just want to know, what is the smooth way of presenting this to not get resistance? Like, I do know I was just in a situation recently where a person contacted me. She was working with another agent. She was very unhappy with the entire process. And eventually she asked me to help her in a transaction. We did go under contract. And then I realized, oh my God, she may be under a type of contract with this other broker. And sure enough, she was. And I did ask her to please send me what she had signed. She had no idea. And so what it meant to me was that other agent made her sign a lot of documents, and embedded in there was that buyer's agency contract. My client had no idea she had signed it, and she had actually signed a contract for 6 months. And really, if we hadn't gone there, the commission for the transaction I entered with her should have gone to the other agent.
That's why we have these classes, so that you understand what's in it and you do exactly what it is. But keep in mind also, that you are required that I think the code of ethics. Well, I think it was a code of ethics. Let me see. Code of ethics, standard practice 16.9 says that realtors, prior to entering into a representation agreement like this buyer agency contract, have an affirmative obligation to make reasonable efforts to determine whether the prospect is subject to a current valid exclusive agreement to provide the same type of real estate service. So code of ethics requires that you ask whether or not that person who calls you is already subject to an existing contract. That's why in this buyer agency contract, one of the first questions is, does a buyer have a buyer agency contract with another broker? That is one of the first questions you should ask, because the code of ethics requires that you ask that. That's the reason it's here in the buyer broker contract, because if they say yes, that should stop everything. If they say yes, I have a buyer broker contract, buyer agency contract with Janine, with Robin, then you should say, well, wait, I need to see it, or I need to find out when is it expire. Why are you contacting me if you have? Well, I'm not happy with Robbie's services. Or when is his contract expired? So that's why you have to ask, because if someone just calls you and you never ask them the question, you'll never know the answer. But if anybody has anything else to add to that, feel free.
I was just going to say, Cecile, if you read it the way Trent did, and explain it to the client, there should be no kickback at all. It's when they don't, it's a lot of my agents, they'll send them out and just pray and close their eyes and just hope that they sign it. And the first word they see is the contract.
Wait a minute, hold on, Bill. I gotta remember. You say they send it out, close their eyes, pray, and hope
that somebody signs it. And of course, I'm not going to sign that if I see that. The first thing I see, this is a contract. It says that at the top. But if you thoroughly explain the contract to somebody, it's not threatening, right? I mean,
Bill, by the way, I will use that. You send it out, close your eyes, pray that they sign it. I love it, but go on.
That's usually where the kickback comes back that I find, but I don't get objections. I explain it thoroughly, just like Trent did, and they go, okay, where do I sign?
So I've never had it either. I've never heard anybody say no. Now I've had people say, I don't want a 6 month or 3 month. Can we do and I'll say, listen, it's up to you. If you want to do just the weekend, you want to do just today, I don't care. So it's up to you. Cecile, what do you say to what Bill said?
No, I hear you. I mean, I know I've never used it, but I do know of agents that are telling me that they do get some kickback. So I want to know that when I'm going to use it the very first time, I want to make sure it's going to happen smoothly. But I know I need to use it.
If you go over it with them, I'm with Bill 100%. You're not going to have a problem. If you go through this contract with them, you're not going to have a problem. It's just when agents give all these contracts to clients and the clients don't have a clue what they're signing, that's when they have some, that's when they have reservations. Because you sending them a whole bunch of contracts, as Bill says, and you close your eyes, pray, and hope they sign it because they don't know what in the heck it is. And that's one of the reasons I don't like DocuSign as much, because I miss the day where I can sit with a client and explain stuff, because now you send everything and you just say sign here, here, and here, and no one's reading it. So I still go over with them. I say, okay, even if it's DocuSign, before you sign it, let's go over this document. Right. But a lot of agents simply send it to them and everybody signs and they have no clue what they're signing.
Sure.
Also, if you have a flat fee, I'm sorry, just want to add one more thing. I'm sorry. If you have a flat fee, you're charging like a $350 or $400, whatever it is, and you don't get this document signed until like a day before closing, and then the CD comes out and they say, well, what's this $400 charge? Well, I wouldn't, you can't hold them accountable to that. They didn't know about that.
They didn't know about it. That's true. Exactly. They never signed a buyer agency contract. Your fee is not in, you can't then say the day before settlement, hey, I charge a broker service fee of $7.95. They're like, well, you never told me. You have to disclose all fees. You never disclosed it. I'm not paying it. And it's too late. It's not even on the closing disclosure. You can't go back and include it. So that's another good point.
So,
anybody?
So look at from my perspective, right? I'm the non-practitioner, right? I'm with the association, but what I'm hearing out of this conversation and the previous sessions that we've done, so going to Cecile's question, right? Cecile was dealing with a client who signed off on a whole bunch of other stuff with another agent, right? So this is an opportunity for all of you to show your level of professionalism, right?
Yeah.
And that initial conversation can be just simply this.
Yeah.
Hey, this is the way I'm choosing to operate my business. I want to do it the right way. And I want you to be informed and know what you're signing off on. So while this may seem like you got a bunch of stuff here and I'm trying to, hitting you with a whole bunch of things, our relationship is one in which it's built on trust. And I'm giving you this information and these documents from that point of trust. So anything that you have a question about, you ask me. I'm here to answer this. I'm not trying to go ahead and give you a document and get you to rush and sign off on it. We're here to do it the right way. And I think like what Bill was saying, like the close your eyes, the Hail Mary kind of a thing. It's like, look, some people are just trying to expedite it. They're trying to do this thing lickety split. And that doesn't, again, going back to that trusting, we're trying to build relationships of trust. And as Trent has always said, hey, look, my business is name integrity. That's by design. It's for a reason. This is the way I'm doing my work. I think that's, you look at that and you raise that level of professionalism, it starts with that initial conversation and how you can go ahead and show a client, hey, this is how I'm going to do it. And look, it gives the client the opportunity. They don't feel comfortable with that, or a potential client at that point, right?
All right.
They can make their decisions. But likewise, what I've learned through these conversations too is sometimes agents are learning too, like, hey, I don't know, this becomes like a big ordeal. Is that the person that I want to partner up with, right?
Right.
I hear that many times.
And you also, and I agree 100% with what you said, Matt, because it makes us seem more professional. Because if you're the agent who's going to sit down with a potential client and go over these documents in a professional manner, as opposed to just sign, that client's going to feel more comfortable with you. That client's going to give you more business. That client's going to refer business to you. And you just stand out because everybody, then that client goes to the office and says, oh, my agent explained this document thoroughly. Another person says, oh, my agent just told me sign. I don't even know what's in it. I just signed. He told me just sign. It does make a difference that's why I go through these things, because I think it's so important that we understand it and we spend time. I mean, these people I was buying, this is the biggest investment they ever making for most of these people. Spend a few minutes or an hour or so going over the document so they fully understand it.
Yeah.
That's what
Matt, I totally agree with you. Cecile, you just have to develop a business professional practice. And, I can't believe it. You've been doing it for 20 years and you haven't had one sign, but I get it.
That's fine. The good thing is that's why we're here.
Yeah, exactly, Trent. That's why we're here.
That's why we're here, because you haven't used it, but now Cecile will use it. But that's why to me, this is a success to hear an agent say, or I've been doing this for 20 years and I've never used a buyer broker form, but I'm gonna start today. That means this was a successful workshop.
Yeah, no,
Cecile,
definitely. I mean, I never wanted to use it because I didn't feel comfortable enough with it. But I do spend an enormous amount of time with my clients going over paperwork so that they know what they are signing, to the point where a few of my clients have become realtors, or a lot of my clients have become actually investors, because they feel so comfortable and they understand the process so well that they want to, for them, it becomes kind of a game. So this is one form that I never felt like I had to use. But now I can see it's very important to do use it. I mean, I cannot go around it. So no, I'm very happy. The workshop is awesome for this.
Right.
Hey, Trent, we got a couple of questions in the chat here.
I see it's one about a non-exclusive buyer agency. What's the question? I mean, what we just went over was an exclusive buyer agency. If you want to use a non-exclusive buyer agency, used in zip forms, it's called an NBA. It's a non-exclusive buyer agency. Not NBA form. So that, in other words, they simply can go to as many brokers or brokerages that they want to help them find the property. I think it's better to use this form and just give them a way out, as opposed to, I would use exclusive right and just give them a termination or make it for a short period of time. I think this is a better, the exclusive is better for you or for your office, I believe. And if they, and just give them, as we talked about, give them a 2 day or 1 day or one property buyer agency contract. But if you want to use a non-exclusive, it's called the NBA form, non-exclusive buyer agency, and you can find that in zip form. I see, I don't think, the home inspection, yes, no matter whenever you do a home inspection on any seller's property, the agreement sale says you must turn that over to the seller. And I have the copy of the agreement sale right here. I'll show you where it says, so it does not matter whether you buy it or not. It says, if you go to paragraph 13, agreement sale, it says, 1, if the results of the home inspection are satisfactory, the buyer will present all reports in their entirety to the seller and accept the information. Number 2 says, if the results of any home inspection report are not satisfactory to the buyer will present all reports in their entirety to the seller and terminate the contract. So even if you plan to terminate this contract, the agreement sale, you still must present the entire home inspection report. And the last one, notice this agreement is to secure my commit to you as a client. I'm assuming they're talking about the buyer agency agreement. Without it, I cannot promise 100% commission. Oh, you're just saying what to say. Oh, I see what you're saying. All right, this agreement is to secure my commitment to you as a client. Without it, I cannot promise 100% attention, as other clients who commit will get the majority of my time. Oh, yeah, I think something like that would work. If you're not going to sign a buyer agency contract with me, this hires me. This is the form that you use to hire me as your agent. If you're not going to hire me as the agent, then you're not going to get the same level of attention that someone who hired me will get. All right, I'm done. Unless anyone has anything else, I hope this was helpful to everyone.
Yes, it was. Thank you, Trent.
You're welcome.
Thank you,
Anyone else?
Trent.
Awesome, Trent. Hey, attendees, awesome job too. I think that was really great. I think one of the really cool parts is, look, we have folks from all different offices doing work in all sections of the city. And the fact that you guys get on and you share and learn from one another as guided through Trent's conversation and presentation, it's pretty cool stuff. So I encourage you guys to jump on any of these future sessions that we do, and please encourage your colleagues to do it too, because you know, it's a great opportunity to go ahead and learn, and for us to help raise the level of professionalism and help you guys do your jobs better and to be more successful. You know, it's a shared success, and you never know who's going to be across the table from you, right? So
exactly.
It's kind of, you know, it's the shared experience, the shared learning, and it's the shared professionalism that makes us all better. So with that, Trent, have a safe drive back home to Philly.
Thanks
you, everybody. Have a wonderful weekend, and we hope to see you soon. Take care, all.
All right. Goodbye, everyone.
Bye, Trent.